political ideology and based more on the law. It's not clear that that is the Supreme Court we have anymore, right? What we have, I think it's clear from the past year, is a Supreme Court that has proven the success of the Republican Party's desire to take over the Supreme Court, right? That is a project that has proven very, very successful on all sorts of topics this past year, from abortion rights to gun safety to environmental law, separation of church and state. On a host of issues, the Supreme Court has lurched the law not just a little bit to the right, but dramatically to the right. Are you guys able to hear this feedback here? Okay, that's okay. Yeah. Okay, so I'll keep talking like this. If this is more annoying to people than that, let me know. Okay. Got it. Okay. I don't know who's watching this on record. Who cares this much about me to be, you're barely here, right? We barely made it. And so but anyways, thank you if you're watching. Well, that's usually it's just my wife listening to me. So that's good, I guess. Okay, so some people, again, just to be clear, some people might celebrate these outcomes on gun rights and abortion rights, but regardless of whether you do, or regardless of whether you happen to agree with me, right, we need to be thinking about the future of the Supreme Court. The Supreme Court has just lost an incredible amount of public trust. So just to give some data, 2 years ago, I guess 2.5 years ago now, after a surprisingly moderate, surprisingly centrist 2020 term, 60% of Americans reported that they approved of the Supreme Court's work, right? That's not just a supermajority. It was a bipartisan supermajority. 56% of Democrats supported the Supreme Court's decision-making in 2020. They approved of the court's work. Over 60% of Republicans, independents did as well. Of course, that's no longer the case. The most recent polling suggests that number is now closer to or even below 40%. 40% of Americans approve of the Supreme Court's work. And why that matters is, for the longest time, Congress and the president, their approval ratings have been below water, right? The Supreme Court was sort of like the one branch the American people had confidence in, would trust. And so even if it ruled against them, they would be like, okay, somebody's enforcing the basic rules of our democratic system. And so I will trust the Supreme Court. If Americans do not trust any of their branches of government, they do not trust the media, right? It is not at all clear why anybody who loses in the American political system would keep playing by the rules of the game if they don't trust any of the rule makers, any of the institutions. So the question is, what, if anything, we can do about this disturbing trend in Supreme Court trust? And I want to try and answer that question in two different ways. One way is going to be complicated. It's going to be nuanced. A second way will be like simpler, neater to explain, shorter, but much harder to actually bring about. I think both of the ways that we'll talk about for responding to the Supreme Court, if you're worried about it, are important. They're mutually reinforcing. We should be doing both at the same time, but some people will be more interested in one or the other, so that's why I'll do both. Okay, so let me start with the nuance, the complication. What should Americans do? For example, if you are concerned about reproductive justice, if you're worried that Dobbs versus Jackson Women's Health Organization has overruled the woman's right to choose to terminate their pregnancy, that a decision in Dobbs that has made it extremely difficult to get safe abortion care in more than a dozen states in the United States. You've probably read or seen stories about pregnant individuals, pregnant minors, sometimes pregnant through rape or incest, who have had to travel across state lines to obtain abortion care, sometimes been disallowed to access care altogether, engaged in medically unsupervised self-care. What to do about stories of pregnant individuals being forced to carry non-viable fetuses to term, to give birth to a stillborn baby because doctors are afraid of being sent to prison for performing a procedure that all would agree is medically required. What can we do, right? What would we do? What could we do if you are a person who's worried about the Supreme Court's decision in a different case, a case called Bruin versus New York State Rifle and Pistol Association? This is another case last June. that struck down laws in California, New York, several other states that limited who could carry a gun in public to people who had a specific reason to carry a gun in public. For example, somebody who, for whom another person was the subject of a domestic violence restraining order, right? A person who had a specific need, a reason to worry that they were in danger for their public safety, could carry a gun in public. But, you know, me, I have no reason to worry that somebody's going to be out there lurking behind every corner trying to injure me. I would not be allowed to carry a gun in public. Laws like this in 8 states in the District of Columbia, struck down by the Supreme Court last year in this case. Those laws, by the way, have led, studies have shown that those laws reduced the amount of violent crime by about 15%. There was actually a Rand Corporation study issued just last week finding that this decision, the Supreme Court's decision in this case, will cause at least 500 deaths per year because of the increase in the number of guns being carried in public. So what should people do if they're worried about that problem? Right? What should people do if they're worried about another case like Carson versus Macon? This is another Supreme Court decision from last summer holding that the state of Maine has to provide publicly funded vouchers, essentially, to parents in the school to attend religious schools, public funded religious schools, because the state also provides funding to private secular schools, non-religious schools. And so the nuanced answer for these cases and other cases is it depends, right? What can we do if we're worried about all these issues? It depends on the case. It's going to be different for every case, in particular, based on the nature of the Supreme Court's decision, the nature of the right the court is recognizing or rejecting, and what states can do in response, right? So the best case is a case like the one I just talked about, Carson versus Macon. This is the Maine case where the Supreme Court says, Maine, hey, if you want to give money to parents to send their kids to secular, non-religious private schools, you have to give public money to religious schools also. That case is actually going to be open to some simple responses that state lawmakers can use to overcome the harms of the Supreme Court's decision, right? Those are cases where the Supreme Court recognizes a conservative constitutional right, a right to publicly funded religious schools is more associated with conservative folks and liberal ones. Therefore, overriding a Democratic legislature's contrary policy. But Democratic state legislatures oftentimes can have creative responses, right? So I'll give you some examples, or the example of what Maine did to overcome what you might think of the injuries in this case, right? So after the court decides Carson versus Macon, progressives are basically, very worried. They're sounding the alarm bells, and they say there are 3 things that are going to happen from this case. One, there's going to be a breach in the wall between church and state, right? States are going to be forced to fund, taxpayer dollars are going to go to private religious schools that engage in religious instruction. That's a concern. Second concern, progressives are worried that this will drain funding from public schools and send them to religious schools. And third, and in my view, most pressing, many were concerned that this Supreme Court decision was going to force states to become complicit in discrimination against LGBTQ students, because it turns out many of the religious schools that want to participate in these publicly funded voucher type programs explicitly discriminate against gay and lesbian students or transgender students, refusing to allow them to enroll. That was true of the 2 private schools at issue in this particular case in Maine. But here's what Maine did, right? Democrats won elections in Maine. They won the House, the state House. They won the state Senate. They won the governor's seat. And so even actually months before this decision was issued, because Maine saw what was going to happen, looked at the court and knew, frankly, there are 6 members of the Supreme Court that are Catholic. So the court was, the state of Maine, they were able to count votes. And here's what they did. They passed a statute forbidding any school, whether religious or secular, any private school that accepts money from Maine could not discriminate against LGBTQ students, right? That's a powerful statutory fix. Frankly, it's a law that should have been in place to begin with, right? Discrimination against these students on the basis of sexual orientation or transgender status is abhorrent for any reason, whether religious or not. But here's what happened. When the state passed that law, all three of those injuries that progressives were worried about went away. There was a report issued a few months ago now that not a single religious school in Maine, after their victory in Carson versus Macon, has agreed to accept Maine public funds. Precisely because they want to continue engaging in this discrimination, right? But because they don't want to take those funds, there's no breach of the church-state establishment wall. Public dollars are not going to religious schools. None of that money is being taken away from traditional public schools. And no state dollars are being used to support or license discrimination on the basis of these protected characteristics, right? We can be really worried about the Supreme Court without throwing our hands up and saying there's nothing we can do. Sometimes it's good old-fashioned lawmaking that can make a difference. It can override the Supreme Court. Let's turn to like sort of a middle case. So let's talk about the gun case, Bruin. This one's a little trickier. It has some similarities to the Maine religious freedom case in that it's the Supreme Court recognizing a new conservative right, a right to basically carry guns in public for any law-abiding or not so law-abiding American, maybe. And that's a right that overrides what blue states are trying to do, sensible gun safety measures, right? So the question is, what can states do now? And the answer here is it's a little bit up in the air. A lot of states are trying. So New York is an example. New York, the week after this case was handed down, they saw it was coming too. They already had bills in the pipeline ready to go. And so the New York State Legislature passed, the governor signed 2 sets of laws. One, limiting who could carry guns in public only to non-sensitive places, right? The Supreme Court's decision says anyone basically can carry a gun in public, can't limit it to just people with a very specific reason. And New York responds saying, okay, everyone can carry a gun in public, but only in certain places, right? And so where can't you carry a gun in public? What are the sensitive places that New York forbade gun carrying? New York included any place where alcohol is served, large gatherings, public transportations, near college campuses, obviously public school campuses, medical buildings, right? A long list of sensitive places that the Supreme Court mentioned in its Bruin opinion, those kinds of laws might be okay, right? So if you're a supporter of gun safety measures, I don't want to give you too big a sense of optimism. A court struck down that law from New York. A lower court of appeals struck down that law, rather a district court, several months ago. So it's an open question whether the Supreme Court will allow those kinds of measures or not. But it's possible, right? Another kind of law states are passing in response. They're saying, okay, we have to allow law-abiding individuals to carry guns in public, but we can make them jump through hoops and hurdles, right? Justice Kavanaugh actually wrote a separate opinion with Chief Justice Roberts saying these kinds of universal requirements that people have to satisfy before getting a permit, those are okay. So what kind of requirements have states imposed? Many have imposed extensive background checks, criminal background checks, mental health background checks. Many have imposed firearms training courses that teach individuals how to safely store ammunition separate from the firearm. Perhaps the most interesting includes a law that San Jose was on the cutting edge of enacting, which is an insurance requirement. If you're going to carry a gun in public, you have to show proof of a liability insurance policy that would pay for any injuries associated with negligent or reckless use of the firearm, right? All of these are ways to ensure that only maybe the safest kind of individuals are carrying guns in public. Still problem. The more guns there are in public, the more guns are used. Guns are disproportionately used to injure people rather than to protect people. Not to say that that doesn't happen also, but the evidence is pretty clear. The net effect is dangerous, but there are some options. Again, I don't want to be overly optimistic, right? Because the court's decision in this case, Bruin, establishes kind of a new test for reviewing gun safety rules. So you may have seen in the news that new test actually could be just as dangerous as the decision, the outcome in Bruin itself about public carry, because the test the court announced is now being used by gun rights advocates to strike down all sorts of other laws, including most, I think, distressingly, federal law for 60 years has made it illegal for a person who is the subject of a domestic violence restraining order to carry a gun. to have a firearm, right? So if you have committed a domestic violence offense and there's a restraining order out against you to protect the victim, right? The assailant cannot have a gun. And the Fifth Circuit, a very conservative court of appeals in Texas, struck that law down, saying historically, domestic violence was like, okay, like there's no problem with domestic violence in 1868. And so in 1868, there was no such thing as a law forbidding a domestic abuser to carry a gun. And so now it's not allowed either, right? We are limited under the Supreme Court's decision to only those kinds of regulations that existed 160 years ago, which has all sorts of concerning implications. Okay, the last example I want to give, this is a situation where, depending on the case, there'll be the fewest options in this sort of complicated, nuanced bucket of what we could do. This is the example of abortion, right? Because what the court's done here is not that it's recognized a conservative right in blue states and it's like sort of challenging blue states to come up with creative other workarounds, but rather the court has taken away a progressive right. And when you take away a progressive constitutional right, the effect is to leave the underlying practice to the whimsy of conservative red state lawmakers. Right? So that's the situation with abortion. And of course, what that means is in 16 states now, it is illegal for a provider to provide abortion care. In some states ever, in other states before 6 weeks in pregnancy, a very early period in pregnancy. And so that means there's not very much that blue states can do, right? There's not much California can do to protect access to safe abortion care in Mississippi or Texas or Louisiana. And that means if one is worried about that problem, the solution is going to have to come at the federal level. It's going to have to come from national action, which means Democrats are at some point going to have to recapture the House of Representatives. They're going to have to retain the Senate. In fact, expand the majority in the Senate by enough to carve out from the Senate filibuster. And they're going to have to keep the White House so that they can enshrine a federal statutory right to abortion. They can pass a federal statute guaranteeing access to abortion care. And that is a tall order, right? That's not easy. And that's, I guess, the segue to the discussion of the simple thing that we can do if one is worried about the direction of the Supreme Court. The simple thing is to vote. It's to get out the vote. It's going to take incredible effort, but this is the most important thing that can be done. If somebody's worried about the future of individual rights and the future of the Supreme Court, the only way to push back is to win national elections and pass federal laws protecting the rights that somebody's worried about, whether it's abortion rights, voting rights, right? These are the kinds of steps that can, the only kinds of steps that can really protect those underlying rights. But while we're at it, if we're going to be able to win these kinds of legislative majorities, there's more that progressives can do. So if progressives have enough votes to pass a federal statute re-enshrining a right to abortion under federal law, protecting voting rights, for example, Democrats should also include in that federal statute a provision stripping the Supreme Court of the power to decide future challenges to that statute. Right? This is in the legal academy, it's known as jurisdiction stripping. Right. So we pass a statute saying there is now a federal right to abortion. There's now federal voting rights. States can't discriminate based on race or national origin or religion in voting access, and requiring states with a long history of voting violations to pre-clear their changes. Right. If we pass that statute, include a provision saying, and the Supreme Court shall not have jurisdiction or power to review or decide a future case challenging that federal abortion statute or that federal voting rights statute. And it turns out that Congress's power to do that, to strip the Supreme Court of the power to decide certain kinds of cases, is on extremely strong footing. Article 3 of the Constitution provides that the Supreme Court has jurisdiction over cases, quote, with such exceptions as Congress shall make. And in fact, Congress has done this before, right? So as long ago as 1869, the Supreme Court has held that it's perfectly fine. Congress has stripped the court's power to decide certain kinds of cases before. Actually, oftentimes in conservative areas, conservative Congresses have taken a liberal court's power to decide certain kinds of cases away from it. And the Supreme Court's always said, yeah, that's fine. That's what the text of the statute obviously means. So turnabout is fair play, right? Either side can do it if they have the votes in Congress. So why might we do that, right? Why might we take the Supreme Court's power to decide questions about a federal right to abortion or federal voting rights? Why might we want to take that away? Well, one answer is probably obvious. It's narrow, it's strategic, which is that the very Supreme Court that has just gotten rid of a right to abortion, that has undermined voting rights at every turn, is very likely to do the same to strike down a federal abortion statute or a federal voting rights statute for whatever reason it can come up with. And so taking the power away from the court to do that it may be critical to protecting the rights that we care about. But there's actually another reason to do this, and it might be even better, which is that taking power, stripping the Supreme Court of its jurisdiction, can send a really strong message to the conservative justices currently on the court. Right? The message is, especially for those more institutionally minded conservative justices, and there are, I think, a couple of them, if they don't come back into the center, into the mainstream of American values on voting rights, women's rights, then the American people are going to take away its power. Right? In the important issues, all the big issues that matter to voters, Congress is just going to say, Supreme Court, you have nothing to say about them. And then such a move, that kind of threat would put the conservative justices to a really important choice, right? They can wield enormous power in the way they've grown accustomed to, or they can keep pushing the law further and further to the right, but they can't do both, right? You can't have power and move the law to the right. If we do that, Democrats are going to take the power away. If you want to have power, that's fine, right? But you'll have to be more moderate, more centrist in how you exercise it. And that kind of choice should remind people of another choice that has happened in American history, another historical moment. In 1937, another Democrat president named Franklin Delano Roosevelt threatened to do the same thing, threatened to effectively emasculate, take the power away from a very conservative Supreme Court that had grown out of step, out of touch with American values. FDR's proposal was different, right? You're all familiar. His proposal was to pack the Supreme Court with additional liberal justices rather than take power away from the Supreme Court in the first place. But it had the same effect, right? It put pressure on those conservative justices to say, we can't keep doing this. We're going to lose all of our power. And so two of the conservative justices switched their votes and adopted a much more moderate posture after that proposal. That's the best case scenario, in my opinion, right? The best case scenario is not actually to pack the court, not actually to take the court's power away from it, but rather to threaten the court and have the conservative justices come to the middle, or at least two conservative justices come to the middle. Because at least with respect to court packing, I'm pretty confident that if the liberals do actually add additional liberal justices to the court, that the conservatives, Republicans would do the same thing at their next opportunity. So frankly, for me, the only thing scarier than raising a daughter in a country where Sam Alito gets to tell her what to do with her body is a country where 6 Sam Alitos get to tell her what to do with her body. But this is, by the way, really the only way that Americans have ever been able to hold people in power in check, including when the people in power wear black robes, right? It's been with real, credible threats to take that power away when we think it's been abused, right? And that's what the threats to strip the court of jurisdiction or to pack the court, that's what those threats would do. Okay, let me say some words about the future, the near-term future of the court. There are a lot of cases, but a couple especially big cases that the court is poised to decide in the next few months that you might have been following in the news. So I'll say a couple words about that before I pause for questions. So one case involves a divisive issue that we're all familiar with. It's whether colleges may take race into account in higher education admissions. So opponents of this approach, affirmative action, have long argued that affirmative action, race-conscious admissions, classifies people on the basis of race and therefore violates the Equal Protection Clause. The Supreme Court held in a 2003 case called Grutter versus Bollinger that no, actually, there's a very narrow way if schools take race into account as one among many factors in a holistic approach, right? If schools can say, hey, we want an oboe player because they're really good at oboe. Hey, we want somebody from Ohio. We don't have enough people from Ohio. Hey, we don't have people of different faiths. We need people from all these different faiths. We have too many men. We need more women, right? If states can do that, one thing they can also do is say, hey, we don't have enough people from this racial demographic or this background. We don't have enough people who speak a different language. Right? Race, if it's treated like one factor among many, similar to other factors in a balanced, holistic approach, would be okay. Now, as you probably know, California has independently, through the initiative process, banned that kind of approach. California has banned race-conscious admissions through Prop 209 since 1996. But roughly half of the nation's most selective colleges actually do continue to take race into account. So on October 31st of this past year, the Supreme Court heard oral argument in two cases, Students for Fair Admissions versus Harvard, and Students versus Fair Admissions versus the University of North Carolina. And the court is basically going to revisit this question of affirmative action. And here's a spoiler alert. The Supreme Court is going to overrule Grutter. It's going to rule that affirmative action is unconstitutional. Colleges cannot take race into account when they make admissions decisions. I think I'm like 99% sure of that outcome. If we're being honest, like some of the 1% scenarios involve like a nuclear holocaust before the Supreme Court can decide the case. But the main reason, right? If you're just counting, we would need the supporters of affirmative action would need 5 votes to sustain Grutter, to uphold that practice. They have 3 votes, likely votes, in the 3 liberal justices, so they need 2 crossover votes from conservative justices. And you might think, who's a good candidate? The Chief Justice, John Roberts, who's been the most moderate of the conservative justices, but he's like leading the charge in striking down affirmative action. He was very dismissive and at times angry during oral argument, disdainful of this practice of race-conscious admissions. So the idea, Sam Alito and Clarence Thomas have already cast votes that they would overrule this case. So supporters of affirmative action would need 2 votes from among Brett Kavanaugh, Amy Coney Barrett, and Neil Gorsuch. And that just doesn't seem likely. So the question is, what happens next, right? If somebody is worried about what racial equity or diversity in higher education might look like in a post-affirmative action world, California is a good example for what happens next. Schools are going to struggle to maintain real racial diversity, real diversity in college classes. There'll be equity implications, exacerbating already rampant inequality in educational opportunity. That'll have social implications, right? Thurgood Marshall, I think, put it as often he did the best when he said, unless our children begin to learn together, there is little hope that our people will learn to live together. I'm worried in this divisive racial climate we already have that things could get worse. There are some things we can do, some of which don't even involve passing new laws. So one small thing folks can do, many of you all are alumni of some very good schools. You have a say in how those schools, as alumni, people care what you have to say about how schools conduct policy. One thing that schools really ought to do, we really ought to stop giving preference to children of graduates of schools, right? We really ought to stop giving preference to the children of wealthy donors. I understand why schools do those things. I certainly do. And I understand why the children of rich people and the children of people who went to really nice colleges would like to continue that policy, but it has huge equity implications, right? Those are all overwhelmingly people from affluent white backgrounds. It goes, I think, without saying that my children did not earn being born to a person who happened to go to a certain school. Jared Kushner did not earn being born to a very wealthy donor who was able to buy his way into Harvard College, right? So these are simple things that I think there is some agreement among conservatives and progressives that we could change, but that won't get us all the way. So you might think, what else could we do? We could give preference to students in the college admissions process based on income, socioeconomic status. So you might think a kid that grows up poor, regardless of whether they're Black or Latino or white or Asian, if they grow up poor, that's a hard life. And if they overcame that kind of adversity to have the kind of grades and achievement to attend an elite college, maybe they should get a preference for overcoming that kind of adversity, right? That happens to be a policy that would also have some equitable implications along racial lines. But that won't get us all the way. So there was a study done about Harvard during the litigation in this case that said, suppose Harvard got rid of its alumni preference, so its legacy admissions preference. Suppose it got rid of any preference for donors, for athletes, and then it also gave a huge preference to poor applicants. What would happen? And the answer is it would be enough to maintain the school's Latino enrollment, but African-American enrollment would still fall by from 14% of the class to 10% of the class, so some 30% on a proportional basis. So that's, if one is concerned about that issue, that's a problem. And I think that suggests that if someone's really worried about this underlying issue of inequality in educational opportunity in the United States, we probably should stop tinkering with the admissions process in higher education. In a way, it's like spitting in an ocean, where the ocean is a broader problem of societal injustice, inequality for poor kids and kids of color. Right? The whole reason we really need race-conscious admissions, if you believe this, in higher education in the first place, is because there's the horrible inequality in K through 12 educational opportunity that precedes it, right? This is an area where I have some firsthand experience. I was a teacher in inner city St. Louis before I went to law school. I can tell you that the kids are just as smart, right? The kids are just as smart in any school. What's different is the school. What's different is the environment, the opportunities we give, right? What's different is it was 3 weeks before I got textbooks to give to my students in 8th grade US history. And I came into the room when I got an email saying my textbooks were here, expecting like a stack of 80, 90 textbooks. I could give one to each student. And it was like this high on the desk, one row. It was like 18 textbooks for 4 classes of 20 plus students. I'm like, what am I supposed to do with that? Like, good luck. Imagine that happening in a nice, wealthy, affluent, suburban public school, right? We wouldn't stand for it. It happens every day in the public schools serving low-income kids of color. If we could fix that problem, if we could provide genuine equitable educational opportunity to poor kids of color, starting from kindergarten, starting from preschool, I'm sure that they would be able to compete for enrollment and seats in the Harvards and the UNCs. So maybe if there's a silver lining, maybe equity advocates might redouble our efforts to focus on these underlying K-12 inequalities once affirmative action is struck down. Okay, I have more thoughts on that, but I'll pause. The last case I want to tell you about is a case called Moore versus Harper. So this is a case that involves a legal theory known as the independent state legislature theory, or ISL theory. That theory has a lot of implications, but I'll tell you about the actual facts in this case, Moore versus Harper, because that's a good way to see what's at stake. So Moore versus Harper comes out of a North Carolina map, a political map that draws districts for the 14 seats that North Carolina has in the United States House of Representatives. Right, 14 seats, 14 members of Congress come from North Carolina. So how do those maps get drawn? You probably know there is a rampant practice in many states, and this is a blue state and a red state phenomenon, a phenomenon of drawing those maps in the most politically cynical way possible. So it's a practice known as partisan gerrymandering. So for example, after the 2010 census, Republicans got to draw the maps in North Carolina. They held the House and the Senate and the governor's seat, the trifecta. And so they sat down to draw a map. And they drew a gerrymandered map that basically guaranteed that no matter what happens, and at that point, there were 13 seats in North Carolina in the 2010 census. Of the 13 seats, they were basically guaranteed 9, no matter how the vote came out, right? So to give an example, in 2012, this is the President Obama's re-election campaign. So the Democrat coattails led to a victory in North Carolina. And so Democrats actually won a majority of the votes in North Carolina House of Representative elections. If you counted all the votes among those 13 seats in North Carolina, Democrats won 50%, 50.1% of the votes. Republicans got 48% of the votes. Republicans got 9 out of the 13 seats, right? How did they do that? Well, we now have computers, and they're so powerful that map makers can know with extreme precision, down to the level of the house on a given street, how that person, the people in those houses, are likely to vote. And when you do that, it turns out you can assign voters to districts in a way that guarantees certain outcomes. We pack all the Democrats in North Carolina in 4 seats. 80–90% of the voters there are going to vote for a Democrat, which means that the other 9 seats can be like 60–40 for Republicans, right? A safe Republican victory, right? But we didn't waste as many votes on Republicans as we wasted votes on Democrats in these other 4 seats. That's how we partisan gerrymandering. And again, Democrats do it too, not as well, not as often. Democrats don't win as many state legislatures as Republicans do. But in Maryland, for example, Maryland's map makers, the former House Whip, Steny Hoyer, described himself as a serial gerrymanderer. Right. So in Maryland, it's always going to be 7-8, right? Or 7 out of 8 seats are Democrats, no matter how many votes Republicans get because of gerrymandering. Okay, so gerrymandering, you might think, well, that sounds really bad. It's going to skew House seats maybe overall a little bit against Democrats because Republicans do it better in more states. But that's actually not the main harm of gerrymandering. The main harm of gerrymandering is it changes the election that matters from the general election, because it's already a foregone conclusion. Whoever the Republican is in this district is going to win. Whoever the Democrat is in this district is going to win. The election that actually matters is the primary. And who can win a primary election? It's the most extreme candidate, the one that's got the largest Twitter or Instagram following because they say the most salacious things, right? And so what ends up happening is partisan gerrymandering has moved both parties to the extremes. It's affected Republicans and Democrats alike, probably Republicans more under some empirical measures. Both sides have abandoned centrist candidates. Centrists can't win primaries. And we've chosen our most progressive, our most conservative candidates. And what happens in the Congress when you have no centrist is you don't pass any laws, right? There's no compromise, there's no deal making. That's the harm of gerrymandering. Okay, let's come back to Moore versus Harper. Why does Moore versus Harper and the independent state legislature theory matter? Okay, so that case arose because Democrat voters in North Carolina were mad about the partisan gerrymandering. So they originally filed a lawsuit in federal court saying that gerrymandered map violates the federal constitution. And the United States Supreme Court said, maybe not, but we're not going to do anything about it. It's too hard, basically. It's the one time the Supreme Court's ever thought something's been too difficult. 5 conservative justices actually thought it was too difficult to strike down this gerrymandered map. And so the Supreme Court said in a case called RUCO versus Common Cause, we're not the people who should solve the gerrymandering problem. Voters should go to state courts. Because state courts, state judges have state constitutions that they can enforce. And whereas there's no such thing as like a fair elections clause in the United States Constitution, many state constitutions have those exact clauses. North Carolina has a fair elections clause. So the people who lost in North Carolina in this RUCO case are like, okay, they filed a lawsuit in the North Carolina courts saying that partisan gerrymandering violates the state constitution's fair elections clause. The North Carolina Supreme Court's like, sure it does. We're going to strike this down. And so the Republican lawmakers in the North Carolina legislature have this idea. They would prefer to keep their gerrymandered map. And so they take this argument all the way up to the Supreme Court, which heard this argument in December. And the argument basically goes like this. On everything the state legislature does, usually the normal rules apply. So if the state legislature wants to pass a law, the governor could veto it. If it's unconstitutional, it violates the state constitution, the state Supreme Court could strike it down. Except election rules. The independent state legislature theory is that only the state legislature gets to make election rules. Governors can't veto gerrymandered maps. State courts cannot enforce constitutional guarantees of free and in other words, if North Carolina had a no partisan gerrymandering clause in the state constitution, that clause would mean nothing because the Republican legislature can act independently to gerrymander and no court can say anything about it, right? This would be a remarkable departure from decades of precedent, from the text of the Constitution, the history of the Constitution. I don't want to talk too much more about it because I think, frankly, it's a frivolous argument. But what I do want to say is, suppose the Supreme Court were to agree, adopt this independent state legislature theory, and allow North Carolina and other states to start gerrymandering again. There's also a risk that we would have state legislatures deciding presidential elections, because it turns out there's similar language in the Constitution that some conservatives have said allows state legislatures alone to choose electors for who wins presidential elections. And so if a state legislature just lies and says the popular vote went for one candidate when it went for another, nothing the Supreme Court of that state could say about it, nothing the governor could say about it. There is an answer. It's the same answer. It's the simple, but not really simple answer I tried to give earlier, which is to win elections, because it turns out Congress also has the undisputed power to regulate elections. There's clear language in the Constitution allowing Congress the power to regulate the manner of elections, how maps are drawn. Congress could, for example, enact a federal voting rights laws that forces every state to assign the act of map drawing to an independent commission of cartographers, right? I don't usually say that word, cartographers, but it felt good just now. Map drawers, who should decide what map, who gets to vote, like whose neighbors get to vote for the same representative? That's a map drawing question, right? You want to know, like, do people live close by each other? We want maps to reflect normal geography. We don't want like these horribly misshapen maps. We want cities not to be divided, counties not to be divided, right? Map makers should be drawing maps, right? And then a lot of map makers, I don't know any, but I assume they're not that partisan. Congress could pass a statute getting rid of partisan gerrymandering tomorrow. In fact, that exact approach, that proposal, independent redistricting commission, was included in the very first bill that the Democrat-controlled Congress introduced in the House in 2021 after President Biden took office. It failed because of the filibuster, but if we won enough elections, we won enough seats, frankly, 2 more Senate seats, 52 senators would have been enough to get rid of the filibuster for voting rights, to protect voting rights, to restore a world in which moderate candidates win elections from either party rather than extreme candidates from both. But again, right, to get that outcome, if that sounds good to you, compromise, the good old days where John McCain would work together with Russ Feingold because they care more about being Americans than caring about being Republicans or Democrats. If that sounds good to you, there's only one party that is arguing for that kind of outcome. We need to get out the vote. We need to show the 9 unelected lawyers in the Supreme Court that the American people have the final say on all these big issues, but not them. Okay, I'll stop now and take any questions.
Hi. Do you feel the Supreme Court is likely to ban the abortion pill? Isn't that a case that's coming up on its docket?
There is a district court in Texas that has been asked to strike down the use of abortion pills. So 53% of abortions performed in the United States today are performed using abortion pills, a pill called mifepristone. It's a very safe procedure, a pill that can be taken at home prior to 10 weeks in pregnancy. There are 2 legal challenges in a federal district court in the most conservative judge in the country. And they've asked him to strike down access to the abortion pill for a couple of reasons. I think it's very likely that judge will say that medicated abortion, mifepristone, was too quickly approved by the FDA, even though every study shows it's safer than Viagra. And B, nobody's coming for Viagra, shockingly. B, that judge is also likely to hold that an 1873 statute called the Comstock Act, which forbids, this is less good on the face of it, doesn't sound good for reproductive justice advocates, forbids the distribution of abortifacients in the mails. That law forbids any company to actually mail the abortion pill, right? So that's another dangerous argument. So this is very much coming to the Supreme Court. It's not this year, maybe next year. This issue is live. What I will say, at least on the first issue, there are 2 different abortion pills, mifepristone and misoprostol. The second pill on its own can be used as a safe pill, and it's not at issue under the first challenge, still at issue in the second challenge. But again, the solution would lie with Congress. We don't need to, part of what I'm trying to suggest to you is we don't need to take over the Supreme Court. We don't need to pack the Supreme Court to protect these rights. We just have to pass a statute, right? You just have to get Congress to pass a new statute getting rid of the ban on the mailing of abortifacients, a new statute saying the abortion pill is safe and has to be used in every state, or can be used in any state.
Hi, I wonder if you would mind returning to the separation of church and state issue.
Sure.
It was always my understanding that the framers were very concerned about public money going to indoctrination of children. And so they wanted, they didn't want that to happen. And that was, I guess in the 20th century, we pretty much could keep a lid on voucher issues using some of the court decisions that were made. But now with this one that you're talking about, how does that, you mentioned Maine's response, but how does that affect those decisions like that ask for religious neutrality across the various religions and also between religion and non-religion that use what's the effect on other states,
Sure.
I guess?
So I'm going to say something here that might be unpopular especially if you're a church-state separationist, somebody who believes this is hard. The honest answer is we don't know what the founders wanted or expected. We don't know what the Constitution requires. Yes, there is a lot of evidence that the framers were worried about public money being used to indoctrinate, especially young people, children in public schools in the Christian faith or a particular faith. There is also a lot of evidence, a lot of reason to think the framers were worried about protecting people of faith from discrimination. So let me give you an example, right? So suppose a state tomorrow were to say, we've got a fire station here, or a fire department. We're only going to allow the fire department to respond to fires and emergencies on secular property because we don't want to get entangled with church-state separation, right? I think pretty quickly people will be like, oh, that feels like discrimination against religious, like against churches. Like you're not going to put out a fire at a church, but you'll put out a fire like a private house or, a brothel or something, right? That seems weird, right? So we're worried about both. And so the honest answer I have for you is I actually don't know what to think about the Maine case on the merits. I'm happy Maine has passed the statute afterwards. But when a state comes along and says, hey, we're going to give money to some parents, only if those parents are sending their kids to secular private schools, but you want to send your kid to a religious private school, a Muslim school, a Jewish school, we're not going to give you the same money that we're giving over there. That doesn't feel great to me either, right? All the answers I want to suggest to the big questions that divide the American people today, there's no easy right or wrong answer on the constitutional question. I actually don't know what the right answer is about the legal question of a constitutional right to abortion. There are really good arguments actually on both sides. I have a policy view, but I'm not foolish enough to think that the Constitution enshrines every single policy preference I have, right? We would do a lot better as a country if we admitted that I think a lot of these questions are hard. The side I agree with isn't necessarily right. It's not wrong. It's hard. And once we admit it's hard, right, that's what forces us to the table to talk about some compromises, some middle ground solutions. If both sides can see the strength in the other side's argument, we could do that. This court doesn't see complexity. It doesn't see difficulty. It thinks every case is easy. And that's part of the problem, I think.
Hi. I have a question about your proposed solution to not have any judicial overview of a congressional statute. Is it just not having Supreme Court or no judicial?
Oh, good.
There's
Yeah.
some scary district courts.
Yes. Yeah. So you're right. We would want to do that. Right. But
And has it been done before? I guess that's the second part.
Yes. So yes, good. Right. So you might say getting rid of Supreme Court's decision to review the constitutionality of a federal abortion right isn't very good if anti-abortion groups can run to this district court in the Northern District of Texas with Judge Kaczmarek and ask him to strike down the statute. And then we don't have anybody to review that. Right. So yes, the complete answer is Congress would want to strip the Supreme Court of jurisdiction and the lower federal courts. The second thing is done all the time. Lower federal courts, their jurisdiction is taken away. It's given to other courts. The real reason to see why that's okay is actually that we don't even need to have lower federal courts. All the Constitution says is there shall be a Supreme Court, and then it gives Congress the power to establish and ordain lower courts if it wants to. It doesn't have to, right? So if Congress could take away all the district courts and courts of appeals to get rid of jurisdiction, most legal scholars agree that they could also take away the power of those courts in certain areas, which Congress has done before. Great question.
A short question.
Sure.
Student loan issue, father of 3 kids. What right does Missouri have to sue this case? Is it being financially harmed?
Yeah.
I mean, that's
God, this is so cool. It's so cool to live in a world where Americans are asking questions about Article 3 standing. I'm not sure. So cool. I mean, I guess it's a special group. You all are a very educated, informed group, so maybe it's not everybody. But all right, I'll give you the answer that I'll give you both sides of the argument, right? The argument for why Missouri ought to be able to sue is that there is an entity called the Missouri Higher Education Loan Association, a private entity that the state of Missouri chartered and spun off as a separate corporate entity, but that Missouri still owns shares in. That entity makes money when there are more loans. Every loan payment that's made, it takes a fee, a small fee in processing that loan payment. And if loans go away because they're forgiven or canceled or modified, and there are fewer loans, there are fewer fees, Mohela, that organization, loses money. Missouri loses money because Mohela loses money because Mohela owns part of Missouri owns part of Mohela. And the court has said before that financial injury by a state, by an ordinary person like you or me, if we suffer financial injury because of some act by the president or some statute, we can sue to challenge it, right? That's the argument for why there is standing. I had to guess 5 conservative justices will agree with that and strike down the student loans. I'm very sorry to report the student loan cancellation policy that Biden's implemented. The argument on the other side is Mohela should sue. They're the ones injured. Other people own part of Mohela too. It's not if Missouri wanted Mohela to be a state-owned entity, just a Missouri loan processing agency, it wouldn't have gone through this act of incorporation, which confers benefits. Right now, if Mohela gets sued, Missouri doesn't have to pay, just Mohela does, right? So, you know, there are benefits to incorporation. States should live with the trade-offs too. Mohela hasn't sued, right? So maybe nobody ought to have standing, but I wouldn't bet on that. Yeah, right. So there are many briefs, and the United States Solicitor General has argued in her main brief in an oral argument, pretty much exactly what I've argued, which is Mohela's injury does not by itself give Missouri the ability to stand to sue any more than, you know, if I bought 1 share of Mohela, would I have the ability to sue because Mohela is going to lose a little money, therefore I'll lose a little money. You know, the argument is that the injury that Missouri suffers is too attenuated. Either Mohela should sue instead of Missouri, or frankly, if Missouri is upset, they should vote Missouri voters should vote Joe Biden out of office. That's usually when people are upset about something the president does, we vote. Now, of course, that if you have 6 justices on the Supreme Court that agree with you, why vote when you can just file a lawsuit? That seems to be the method of governance we have increasingly today. But standing, this idea that somebody has to actually be injured in a personal way by some presidential act is supposed to be a rule about channeling disagreement to the political process rather than to the courtroom.
Okay, back to gerrymandering. Did Baker versus Carr in Georgia in 1964, didn't that set a precedent for the Supreme Court to deal with this issue?
Baker versus Carr is about a different problem, unfortunately. Baker versus Carr is about malapportionment. So this is a problem where I think in California, actually, there was one district in 1950s in California that had like 6 million voters to elect 1 seat to the California Senate. And then another district that had like 17,000 voters, right? And there was similar inequality in this California House and a lot of states. Baker versus Carr establishes the rule that you can't do that, states. You have to have everybody's vote be about the same value, 1 person, 1 vote, right? So you can't have lopsided districts with more people whose votes count for less and some with few people whose votes count for more. Partisan gerrymandering is different. It's a problem not of the size or the number of people in each district. It's about the political party to which the voters belong. And the reason why Baker versus Carr doesn't really help with that as much is everybody seems to agree we are okay with some gerrymandering. Every map's drawn since the very first maps in the 18th century were written for political advantage. So we have it's a hard question. Partisan gerrymandering is. It's not hard in my view whether we should have a statute getting rid of it. That's easy, but the legal question is actually tricky.
Okay, we have a last question.
Hi, this idea about expanding the court was getting a lot of traction a while back. And one, how does that happen? And what do you think the likelihood is of that, or some other sort of restriction, term limits or age retirement,
Yeah.
you know, is likely to happen in the near future?
I think the odds of expanding the court, adding more liberal justices, let's say over the next year, before the end of the Biden administration, is 0%. How it would happen is through a statute. Congress can change the size of the Supreme Court by statute. There's nothing in the Constitution that sets it at 9. It's been at different numbers at different points in history. But it's not going to happen for political reasons. And frankly, it shouldn't happen for political reasons. To expand the Supreme Court, senators would need to get rid of the filibuster to pack the court. At the point at which you can get rid of the filibuster, why are you getting rid of the filibuster to pack the Supreme Court, something that makes a lot of Americans, even me, queasy, when you could just pass a statute protecting the right you care about, voting rights? Carve out the filibuster and protect voting rights, something most Americans actually should agree with. Protect access to abortion care, which is something most Americans agree with. Just do that, and while we're at it, strip the Supreme Court or strip all the federal court's power to strike down those laws. That strikes me as accomplishing what many Americans are concerned with, without the specter of of ever escalating cycle of 9, now 13, now 21 justices. That is frankly what happened in Turkey and Venezuela and Hungary before their democracies largely collapsed.
We're out of time.
Happy to chat with you afterwards on it. Thank you all.
Professor Tang, thank you for this very enlightened presentation and amusing as well. As a small token of our appreciation, we're making you an honorary member. Can you hear me? Okay. As a small presentation, rather token of our appreciation, the Renaissance Society is presenting you with an honorary membership. And we will make a donation to the Seth Nelson Student Emergency Grant Fund in your name.